SJC-13666, Jaklin, Suzeth, Gotay et al. Versus Julianne Creen et al.
Okay, Attorney Dirks.
Good morning, and may it please the court, Catherine Dirks for the 4 social worker appellants. What happened in the foster home of Kimberly Malpass in August 2015 is a tragedy, and Ms. Malpass's neglect of Samara Gotay is a terrible thing. It should have never happened. In the interest of time, I would like to first make clear 2 points that my clients agree with. First, we agree that substantive due process applies to children in state foster care who are entitled to having their basic human needs met, including reasonable safety. 2, we agree that as to social workers, the law did clearly establish a version of the substantive due process test. I'd like to spend my time this morning on the 3 areas of disagreement. 1, what that test is or should be. 2, whether that test was clearly established. And 3, whether that test can be satisfied here, where the material facts are not in dispute. Turning first, Your Honors, to what the test is or should be. Based on our review of the persuasive authority, there is no controlling authority. What was clearly established is that a foster child's due process rights are violated when a social worker shows deliberate indifference to a known substantial risk of severe harm in a way that shocks the conscience.
Why treat children under the care of DCF the same as prisoners?
The courts have acknowledged that there is obviously some difference between children and prisoners. Children,
substantial.
obviously.
Yeah, thank you for acknowledging that. But why not adopt, as
Youngberg.
I think the 10th Circuit has, the Youngberg standard?
That's right. Youngberg is interesting, Your Honor, and Youngberg is also very different from this case. Youngberg involved a state mental hospital, and whether a developmentally disabled adult should be physically restrained. And the defendant in that due process test was not a social worker, it was the administrator of that state hospital. So when the Supreme Court articulated the professional judgment standard that's there, and that in some ways is being advocated by the plaintiffs, the Supreme Court defined what it meant by professional. I would point the court to footnote 30 of the Youngberg decision, which talks about training, expertise, it talks about nursing and the medical facility. And for some reason, the 10th Circuit decided to apply that professional, specialized set of standards that applied to a state mental hospital, and it applied it to social workers.
Right, and the reason the 10th Circuit articulated was that children deserve at least or better care, a better standard, a better test than prisoners. And I guess I'm wondering why the state's position in this case is that that rationale doesn't hold sway.
The reason I find that language in the 10th Circuit puzzling, Your Honor, is because it suggests that prisoners are somehow not entitled to incredibly robust 8th Amendment and 14th Amendment protections, and they are. They are absolutely entitled to
But the question isn't about whether or not prisoners are entitled to. The question I'm asking is whether or not children under the state's care are entitled to any better protection, which the 10th Circuit decided they are, than prisoners. It's not, you're flipping the question. Prisoners, of course, have an 8th Amendment right, and the test under that is deliberate indifference. I'm wondering why the state's position is that that children should be subject to the same test.
A few responses to that, Your Honor. First of all, we're talking about individual defendants, not the obligations on DCF more generally. And with respect to individual defendants facing constitutional rights violations, the authority across the country is consistent that that is a deliberate indifference standard. Whether the harmed individual is in prison or in state custody through the child care system, the foster care system, the question that must be posed to an individual defendant is the same. So one, if this court were to branch off in the same way that the 10th Circuit has, that would not be clearly established. So that would be a new type of test. So setting that aside, the reason that test should not be applied here is because if this court were to adopt a professional standard test for something like social worker decisions, where the child is not necessarily under the day-to-day scrutiny and control of a state facility, as in Youngberg, then the test would very quickly collapse into a negligence standard. And the Supreme Court has said that substantive due process cannot be negligence. In fact, I'd point the court to some language in Youngberg itself. This is Youngberg, page 321. The quote from the case is, "It is not appropriate for the courts to specify which of severally professionally acceptable choices should have been made." So in this context, it would be very difficult for a court to look at the complex decisions that social workers have to make on very specialized facts that often involve very difficult credibility determinations, and to prescribe a rule as to which of different professionally acceptable choices is the best choice.
Well, I thought the Youngberg rule was that if there are these variety of different professional choices, no liability.
That's right, Your Honor.
But why would that standard devolve to negligence, as you say? I mean, I thought Youngberg specifically said this is not negligence.
Yes, Your Honor. So if you have a context, a professional environment, where there is a clear professional path forward, right? There is a clear professional standard, and it would be very, very easy for any professional within that context to know what would constitute an abdication, an extreme deviation from that professional standard, then you could apply that test. But here, where you're talking about a moment in time, where you have different individuals making competing and conflicting statements about the facts of a foster home, the plaintiffs do not put forward what professional judgment would have required. Would it have required once a week visits? Would it have required a certain number of unannounced visits? There's nothing in the expertise and training that social workers provide that would have defined exactly what to do in a situation like this, where the allegations were found unsubstantiated, where you have an investigation that occurred over 17 days.
But you're now applying the test. I thought your first point in oral argument was going to be what test?
Yes, Your Honor. And turning back to Youngberg specifically, there's a reason. The reason that the deliberate indifference test has been applied here is because of I was using this as an illustration, but the challenges that individual social workers face. Now, it is true that there are cases that have talked about the responsibilities on the foster care agency, and that's what Connor B is, which gets to why this is not so clearly established at times, because the First Circuit in Connor B did talk about Youngberg. That was not a damages case. It was not an individual social worker liability case. They were grappling with what remedial actions were required of the agency going forward. And they talked about the Youngberg standard. But when the First Circuit then turned to the individual social worker obligations, it then reverted to the deliberate indifference standard and explored some of those reasons. I would recommend to the court the KH decision written by Judge Posner in the Seventh Circuit, which really grappled with some of this and really explored why qualified immunity is appropriate in these circumstances and why knowledge of harm is the grounding factor in these circumstances. And Judge Posner articulates it much better than I could.
Can you address the causation issue? Because from what I understand, the tragedy here is this 2-year-old turns up the thermometer while everyone's asleep or passed out drunk, but I'm not sure I understand exactly how this plays out. Because if this were a case where this guy was a domestic abuser and you put him, or he's a case where a guy abuses children and you didn't screen him carefully enough, and he abuses the child. Whether we're doing the deliberate indifference or the Younger standard, the results are the same. But here we got this complicated causation issue, right? That the cause of the injury is not the danger presented by the man, is it? And what's the causation standard in this area?
The Second Circuit answered that question to some extent. It talked about proximate cause as being embedded in the substantive due process analysis when it comes to individual social workers. That's the Doe case. cited in our briefs.
So how does that apply here?
So we would, I want to make clear that we would not maintain that this specific event would have to be anticipated. It's not, in order to hold a social worker liable, you wouldn't have to say that they contemplated the thermostat being changed. But what would have to be contemplated is a risk of this type of gross neglect, gross abandonment. And that's not part of the causal chain here when you have an allegation of a single instant of physical harm inflicted by Mr. Mallet.
But the foreseeable risk here, if I'm doing proximate cause, is that putting this man in this house presents a foreseeable risk of what? That he is going to neglect the child, but, right? I'm getting.
I suppose that's what plaintiffs would argue. I mean, the best I could do if I were plaintiffs.
Well, no, I would think you'd be arguing this hard because he doesn't, if he had fallen asleep or she had fallen asleep, right, this tragedy would have happened anyway. I'm just confused by why you're not focused on, I understand why he may not be, but I'm confused why you're not focused on the causation issue.
Well, we do argue it in the brief, and we cite the Doe case. There are many things we have to focus on, and I want to make, to some extent, I want to make clear that the legal issues here are dispositive. But even in the record, we have a situation of where there are no material disputed facts. The sequence of events from March 2015 with this 51B report and the August 2015 thermostat issue are simply too attenuated. Let's say that Mr. Mallet had not been in the home. This could have occurred anyway. She could have hired a babysitter and gone out and come back intoxicated. Now, can we say as a matter of...
Where she wasn't intoxicated. She just went to bed like a normal person. How would she have known? I'm just trying to understand this. That's what I don't get exactly. This is an extremely subtle difference between these two tests, whether it's younger or deliberate indifference. And this is clearly some negligence on the part of the social workers, but the causation thing seems to be the 600-pound, gorilla in the room. I just don't see the connection yet.
Well, I think it's all embedded into the knowledge element, Your Honor, which is the only piece of this test that has been clearly established as a matter of persuasive authority, which is that did they know this was going to happen? Not even this specifically. Did they know that the foster care was going to abdicate her duty in this way? What happened in August was contrary to everything they knew about Ms. Malpass. This is in the record, and this is in our briefs. She had a record of positive performance evaluations, not only from Ms. Peterson and Ms. Creen, but from 2 other social workers as well. The dictation is there from Ms. Creen. It shows that she was consistently raising medical issues about these children and making sure they got to their doctor's appointments. The house appeared to be in order. The only allegation that occurred during her time as a foster parent that was about abuse and neglect was this 51B from March 2015, which was found to be unsubstantiated. And if the court were to read one part of the record, Your Honor, on this point, on this causation point, it would be the 51B itself, and that's in volume 2 of the record appendix. It's 27 pages, pages 189 to 206. Plaintiff's claim is hooked on that investigation report. The only way plaintiffs could succeed is to say that something in that report made it clear, compelled knowledge on these individual social workers' part that these children were in danger. And there's nothing in the report that would compel that kind of conclusion.
Well, I mean, to be fair, the report does say that Mr. Mallet was present at the home a lot more than Malpass indicated. It includes the Corey for Mr. Mallet, which includes a long criminal history, including assault and battery and robbery. So that is tagged to your client's knowledge. why wouldn't that have been a sort of a known risk that they're placing or continuing to place kids in an environment with a woman who is not being forthcoming and whose partner is got this lengthy criminal history, and he's around these kids a lot?
Well, to clarify the record, Your Honor, the finding wasn't that he was in the home a lot. It was that he
A
had
lot
been in the
more
home-
than she had said.
I believe the phrase "a lot" does not appear. The phrase is that he was in the home more often than she had reported.
And nobody followed up on that.
Yeah, I'll contest that, Your Honor, but I'd also just like to clarify that also in the record, also in that report, was that he says he had not been in the home when the foster children were there. So there's nothing in the report saying that he had had any contact with the foster children. What there was is that they clearly had some sort of relationship, whether it was romantic or not. He had been in the home more often than she had previously reported. And then the investigator said he confronted Ms. Malpass about that. She claimed that she had not understood the DCF policy requiring approval of individuals who were frequent visitors. And he said this happens a lot with foster parents. They often don't understand. She understands it going forward. Basically, we've cleared this up. She now knows the rules. And then with respect to your second point, Your Honor, about no one following up, it's also undisputed that they did follow up, that Ms. Creen did have a conversation with her after this to explicitly and clearly say that he was not allowed in the home. And we have evidence that Ms. Peterson, who was not the social worker assigned to the home, but rather to Samara, that she actively looked for evidence of a male presence in the home and that she found none.
So what is the deliberate indifference to a known risk of harm? Because I was with Justice Kafker on the causation thing, because the risk of harm here that was foreseeable from Mallet was that he would do some sort of abusive behavior against the kids. And so when you say the social workers did not know of a known risk of harm, what are you referring to in your brief? That Ms. Malpass was grossly negligent?
Yes, Your Honor.
Okay, thank you.
I think you could even if the harm that had occurred was that he had abused Samara, that he had injured and inflicted an injury similar to what was alleged in the 51B.
You still think
Then
your
I would-
client would get qualified immunity?
I think so, Your Honor, because it was not known necessarily in the report that he had done that. Now, recall that the test here isn't knowledge of a
Well, the report
non-zero-
pulls his Corey, right? And so
Pardon me, Your
the report pulls his Corey, so you know what he's done in the past, which is including assaultive behavior.
Yes,
That's
Your
a
Honor.
question. Yeah, okay.
So if it had been known that he was living in the home, that might be different. There might still be qualified immunity, but maybe we wouldn't be here on summary judgment, Your Honor. Maybe we'd be here after a jury verdict. But that's not this case. So what we have is a knowledge of a risk that he was in the home more often, known that he was in the home more often than had been reported. Not known that he was living there. Maybe some non-zero chance that the allegation that he had injured this other child was true, but not more likely than not, right? Because you have an investigator who said that he didn't find that credible. So you have this sum of maybe non-zero risks, but that aren't more likely than not. And could you add those together to somehow prove that these social workers knew these children were in danger? There's simply no case that has found that. And I would point the court to several decisions that have faced very similar circumstances and ruled in the social workers' favor on qualified immunity grounds at the summary judgment stage.
If the social workers, as I understood at least one theory of the plaintiff's case, is that the social workers failed to take the steps necessary to adequately inform themselves of what was going on in the house, the situation in the house. If that theory is a sustainable theory, then the fact that they don't know things doesn't really seem to me like a firm basis upon which to give them immunity, right? It'd be like rewarding them for turning a blind eye. I'm wondering how you would distinguish, or how your theory would square with not allowing immunity for workers who just turn a blind eye to the risk of harm.
I think that's a concern that's a through line in all of these cases, Your Honor. The employee who holds their ears and say, I can't know it because I'm not letting you tell me. In a way, that's a tension that's found in all immunity cases, right? Are we going to allow certain behavior to go unchecked because it falls on a certain line? But on the other hand, imagine the social worker, Your Honor, who has good faith, is a public servant. These aren't CEOs of Fortune 500 companies, they're social workers. They're presented with complex facts. Maybe they don't follow up on certain leads. Maybe they look at a foster parent who seems like a pretty good foster parent. She does some extra work for DCF. She calls the social workers a lot. They end up believing her. Maybe they weren't as skeptical of her as they should have been. The question is really for that good faith social worker, are we going to allow social workers in Massachusetts to face jury trials and potentially ruinous financial liability for their failure maybe to follow through as well as they could have? And courts that have addressed that exact tension have consistently found that on balance, we need to provide qualified immunity to those types of social workers. I'll just give the case names in the interest of time. I see I'm far over my time. But Lintz versus Skipsky, that's out of the 6th Circuit, cited in the briefs. James versus Friend, that's out of the 8th Circuit. And Cox versus Department of Social and Health Services, that's out of the 9th Circuit. All of them involved some indications that maybe physical harm had occurred. Again, back to the causation question, it was indications of physical abuse that weren't substantiated. It turns out physical abuse had been occurring, or sexual abuse, that close tether. And even there, the issue was that the social workers could have done more. They could have done a better job. And even there, that was not enough to rise to the level of a substantive due process violation.
Okay,
I'm far beyond my time. Thank you very much. I rest on the papers.
thank you. Okay, Attorney Ruskell.
Thank you, Your Honors. May it please the court, David Ruskell for the plaintiffs. We're here today because 2 children were injured and a 3rd one died because DCF and the 4 appellants knew of the risk presented by a dangerous person with a history of violent crimes and restraining orders being present in the foster home. They discussed measures to take in order to address that risk, and then they just didn't do those things for months. What they did instead was cover for the foster mother who volunteered.
Can I push you a little bit? If he had harmed the kids himself, or if he were selling drugs and someone broke into the home and hurt the children, easy case to me for you. But the injury here comes from a 2-year-old turning up a thermometer. Connect me to that, the known risk of him not being the right person to be in the house and the actual injury here. Doesn't there have to be a causal connection between the two?
Absolutely, Justice Kafker, and I did want to address the causation issue that was raised. So the risk that we're talking about is the risk that a person who is disqualified by DCF regulations and policies from being a frequent visitor or living in the foster home was there, and was there more than the foster mother disclosed, and she lied about it, all that. But the risk is that, one, that the foster mother would neglect the children by leaving them with this unsuitable person. And one of the 51A allegations was that he was a caregiver, even a primary caregiver of the children. So they were aware of that risk. And 2, that he...
Was that supported?
That was not supported in the 51B, but that was an allegation that they were aware of and that they discussed. The second is the risk that Mr. Mallett would neglect the children. And the way it actually played out, as far as everyone could tell from the inquest, is that Ms. Malpass neglected the children by leaving them with an unsuitable person, Mr. Mallett. He was the sole adult in the home at that point. She came home drunk and unable to care for them, and then he neglected the children by saying, "This is your problem, I'm going to take 2 Xanax and go to sleep." And then she slept in and didn't check on the kids until noon. And during that 12-plus hour time period where the children were left unattended, and having been put to bed by Mr. Mallet, or I think there's evidence in the record suggesting that he had a third grader help put the children to bed. They were left in this vulnerable position where tragedy could happen. And so the causation is, the risk is this unsuitable person is here, and either the foster mother or the boyfriend or both will neglect the children, and that is what happened. That
Is
is
there
the
any
causation.
evidence in the record that the boyfriend, or whether it was boyfriend, I don't know, was in the house at the time the foster mother was approved to be a foster mother? The time when the children were initially placed there? What's the earliest that maybe another way of I'll ask you now a fourth question. What's the earliest that the record would support a finding that the boyfriend was present in the house more than just a occasional visitor?
I believe when he was questioned after the tragic incident, he told the state police that he'd been living there for a year and a half. So I believe
But that wouldn't have been known to the, okay, so just what would be the earliest that would put any of the DCF employees on notice?
On notice that he was living in the home?
Yeah, that he was there more than as a casual visitor.
Well, the 51A certainly had allegations that he was there frequently. And then the 51B report...
That was in March of the, how long was that before? That was what triggered the 10-person meeting, correct?
That's right.
Okay, so that would be the earliest notice to DCF workers that a man was present in the house more than he should be without being approved.
That's right.
Okay, so if that's the case, then how do any of the, I'm just going to call them lapses, you may call them failures, or shortcomings of the placement investigation at the outset, how do they fit into the theory? How do they help support liability? Because the ultimate risk that you're talking about is the risk that the foster mother would leave the child in the care of this unsuitable person, or that he would have care of the children. So if there's no notice to them that this is an issue before that 51B report, then how do you get in, and how do any of the early acts matter?
Well, in terms of the placement decision, the earlier acts, they're there partly for context, but also for the fact that the home was inappropriately approved for as many children as were there. Based on the size of the home, it should have had no more than one female foster child. It had 3 or 4 at the time of this incident.
I get that, but doesn't that really have a causation problem?
I think for purposes of this claim, and I think we're focusing on primarily starting at the 51A and the notice that this man was in the house, and then proceeding from there. So the rest is valuable context for the later lapses.
Okay, so, all right, so if that's the case, do the earlier shortcomings that you've identified, then are they pertinent to the qualified immunity calculus?
They're relevant to the state of mind, particularly of Ms. Creen and Ms. Johnson-Cruz, and the degree to which, to the extent that this court believes that deliberate indifference is the standard or relevant consideration, the lack of care and the lack of caring that those individuals displayed, continuing from before the 51A to the end of the story. So it is relevant to that extent. One other thing that I wanted to point out is, in terms of what Ms. Creen knew from the very beginning, from the 51A, her dictation reflects that she spoke with Ms. Malpass, and the initial story she got was, I barely know the guy, I dated him 10 years ago, you know, I don't have any relationship with him. They go to the meeting. There are photos on Facebook of the two of them with hearts together. And then she's telling the 51B investigator, oh, well, you know, he was here, but not at the home when the foster kids were there. And yeah, we went on vacation together. And that further put the defendants on notice that they needed to do something. So the question was raised before, what did professional judgment require? Professional judgment required that they do something to address the risk that this man was in the home. And in fact, Ms. Creen and Ms. Johnson Cruz developed a plan of what they believed was necessary. They believed it was necessary for, between the different social workers who were coming to the home, to have weekly visits. And then they just didn't do that. In 5 months after the 51B, Ms. Creen visited the home 3 times. My understanding is she was supposed to do that at least monthly, that she had, you know, not visited as often as she was supposed to before that.
How do you deal with the JR case?
Absolutely. So the JR case is a situation where the defendants knew that there was a man in the home who had not been subjected to a background check, but that's all they knew about him. Actually, to the extent that the defendants there had more information about the man, it was positive information. They knew that he had been involved in the care of these kids and had gone with them to appointments. They didn't have red flags of this man has a disqualifying query, which is what the defendants here had in the 51B. They knew about the violent charges, about the 6 209A orders with different women. They knew that there were reasons why he was disqualified. That is, so not conducting a background check in JR, that was negligent, that was a violation of state law, but that wasn't a constitutional deprivation because there wasn't more to put the social workers on notice that they needed to inquire more. I mean, in this case, 2 other social workers believed that removing another child was required right away, that, you know, we got to get JE out of this home right now. And they did that on the day of that meeting or the next day. These defendants subjectively recognized that visits needed to be stepped up. They didn't do that. They had information in the 51B that...
Did they talk to Ms. Malpass?
I'm sorry?
Did Creen talk to Ms. Malpass about Mr. Mallet not being allowed in the home when the children were there?
She had a discussion with Ms. Malpass. I think there's disputed evidence in the record about the content of that conversation. There's evidence that what she told her was get that information off Facebook. It's incriminating. You don't need people seeing your business. That she was giving her a warning rather than actually addressing the issue. And I believe Ms. Creen testified that she didn't inquire of Ms. Malpass how often Mr. Mallet had been there, which was a really important issue, a really important thing to have known, and she didn't even ask that. So what she told the 51B investigator was, I think she made a mistake by bailing this guy out of jail on a robbery charge, but I like her. And she did like her, and that clouded her judgment so that she failed to exercise professional judgment. And we've got the Wisniewski affidavit in the record that's really a roadmap to all the different ways that the different defendants failed to follow established policies and practices and displayed an absence of professional judgment. I want to, on the standard that applies, I do want to say that I think Lewis and Lewis's discussion of Youngberg in particular really kind of answers the question of what the standard is. Lewis says, here's what we mean by shocking the conscience. It's a spectrum. Mere negligence, that doesn't qualify. Intentional infliction of harm, that does. And in the middle, it depends on the circumstances, and particularly it depends on whether there's time for deliberation. And, you know, obviously some of the precedents deal with prisons. If it's a prison official dealing with big questions of conditions of confinement, they have time. That is something where they have to exercise professional judgment. If they're dealing with a prison riot and it's an emergency, then we're going to require a higher bar for liability. Here, if we were talking only about the decision on March 5th, do we remove these children right now? Then it might be that there would be a higher standard for liability. But here there were months after that where there could have been more visits, should have been more visits, they knew there should have been more visits, and they did nothing to address the situation.
And more visits would have identified possibly him being in the home if they were they knew how many kids were in the home. The visits identified, right, the location of the kid's bedroom where they slept. I'm just trying to figure out what the additional scrutiny would have shown. It would have shown Malpass being there more often, but because is the room itself part of the recklessness, the way the room was set up? It sounds to me, again, I'm back to causation a little bit, and you've made some good points that, okay, they slept until noon, and do we know when, do we have a medical report estimating the time of death of this child? Do we know? We don't have
I don't believe we have a time of death.
Right, I'm sure. So the negligence here is, in certain ways, I'm trying to connect it to the death of the child. So you say there are more kids in the house than there's supposed to be.
Right.
The care tenders are sleeping till noon and drunk or on Xanax. All of this contributes to the death. And again, the negligence on the part of the DCF workers, they weren't there often enough, but again, they would have identified the location of the cribs and stuff. So help me out a little bit more. I'm starting to understand your causation theory, but I'd flesh it out as much as you can.
Right. So the things that that additional visits or more thorough visits would have established were, and particularly if they had done unannounced visits, and I want to get back to that in just a moment, would have uncovered that Mr. Mallett was there when he wasn't supposed to be. And also the factor which was in the recertification, the annual recertification of the foster home of how many kids are here, is there adequate space. In the recertification that was done in, I believe, January of 2015, Ms. Creen checked off, is there enough space in the bedrooms? Is there 50 square feet per child, I think it was. She checked off no. So she recognized that. But nonetheless, the foster home was approved to have as many children as it did. Now, in terms of unannounced visits, the one thing that all the defendants knew as a result of the 51B was when an emergency response worker, CES, a contract worker working in conjunction with DCF, came to the home late at night, there was a man there fitting Mr. Mallett's description, and Ms. Malpass refused to answer the door. Now, that's information that professional judgment says, well, maybe we should think about having an unannounced visit at some point instead of letting them know ahead of time so he can get his stuff out of there. So that's also information that they had. But the increased visits would have showed signs that Mr. Mallett was there, and the adequacy of the sleeping arrangements. No further questions? I see my time has expired.